see that we have a number of our participants joined. We're live on Facebook. We've got some people watching on Facebook. Anybody on Facebook who's watching, you're welcome to also shoot questions our way, just in the comments section, or send a direct email or DM. Sorry, I'm not using the proper term. DM me on the Arteezy Zandri site, and we can also answer your questions. So let's get into today's topic at hand. You know, the many layers of executive compensation closely held small businesses can add just so many more things to a divorce. While some divorce cases are relatively cut and dry from a financial standpoint, when there is, you know, executive comp, very large executive compensation packages, or small businesses where there's families involved and partners, it can really make it way more complicated. And if it's not properly handled, you can really leave either money sitting on the table, depending upon which side you're on, or you could be overpaying. So we had done a coffee talk, I think it was maybe our third or fourth one, where we had a number of questions about small businesses, and that was why we thought that this was an important topic. So Paige, I'm going to start with you. Can you kind of just review for everybody, why is this really even important? Obviously, I mean, again, with the multi-layers, but what's at stake if it's not handled properly?
Well, as you pointed out, you know, from the perspective of the person owning the business, you want to obviously protect your asset, but that asset, if it is created during the marriage or, you know, grown during the marriage, whether it's, you know, whether it's a business interest or it is income or deferred comp or some sort of equity comp that an executive would be earning, you know, that is often considered a marital asset. And the risks that you run into are, you know, how do you value those assets? Which portion of that asset is a marital asset if it's not the entire thing? You know, and when you are looking at that particular asset, does that asset also generate income that will then be considered for purposes of calculating spousal and child support? So that's an issue of double dipping that we can dive into a little bit. But, you know, it's really ascertaining the value. What portion of that value is marital? Then in New York State, we do not distribute marital assets equally. You know, there is a presumption, especially in long-term marriages, that you start from a presumption of 50-50 division, but we have equitable distribution. So there's a laundry list of factors that parties use to make arguments as to why it should be something different than 50-50. So all of those things are critically important, especially when those assets are the primary assets that the couple might own.
Yeah. Can you, you know, it may seem simplistic, but even for my own sake, and can you kind of outline what types of businesses we're talking about? I know we've kind of mentioned that getting ready for this, there was like cash businesses, maybe give some examples of that. And then in the same vein, you know, when we talk about executive compensation packages, what sort of like, you know, big things are we looking for on an executive comp package?
So you definitely, as you mentioned, for closely held businesses, you're definitely going to want to dig into the weeds for any type of cash business. So restaurants, dry cleaners. Lauren, jump in here if there's anything that pops in, like nail salons, hair salons, service-based businesses.
Yeah, any sort of like commercial and service-based businesses where people pay in cash. You know, like when you're selling bigger items, like higher priced items, you're probably not going to have so much cash. If you're selling online, you're not going to have cash. But in I think any sort of service industry where you go in and you're paying, like you're getting the service and you're paying, those tend to have a lot of cash receipts.
You know, and then you're also looking at, I agree, yeah, and you're also looking at closely held businesses where there's no real marketability for the business. If the business is largely service-based and your spouse is, you know, without your spouse, that business does not exist. So, and then you're also looking at, you know, now in the age of tech startups, you're looking at small businesses that have high potential for growth, rapid growth. And you're talking about, you know, valuations that go from $0 to many millions of dollars in the span of, less than 2 years. So so those are examples, and I'm not sure, did I answer the totality of the?
Yeah, you definitely did on the small business end. What about on the executive comp end? What sort of things are we looking at on an executive comp thing that can make it really layered and difficult?
Well, you definitely want to look at employment agreements, if whether or not you have, signing bonuses, whether those signing bonuses are paid out over time, whether there's incentive-based comp for staying with the business, whether bonuses are just supposed to be paid out every year at a certain amount or at a certain percentage. You want to look at equity grants, and those can happen either annually, quarterly, those can happen randomly. And you want to look at, also whether or not there are any, if for any reason your spouse is severing their relationship with the company, you want to also be looking at those severance agreements.
Right. Okay. So I think that's helpful, at least for me, because I'm not somebody who has a large executive comp background. I know actually something else that was interesting, Lauren, that you talked about, and this is not an executive comp thing, but on the civil service side, police officers and union, sometimes they have sick days, large banks of sick days that can be paid out in retirement. And I thought that was an interesting. Can you just touch on that real quickly?
Yeah, no, a lot of government jobs and civil servant jobs have arrangements where they can carry over their sick days and their personal days. And at the end of their career, they've accumulated, this large amount of, days of, and it translates into money because they're paid out when they retire. So you want to make sure, a lot of people when they're getting divorced, they're not getting divorced at the time of retirement. You want to make sure that you preserve your interest in that and preserve your right, because if you're entitled to, as the spouse that doesn't hold the asset, you're entitled to the marital portion, your share of the marital portion of that. So it's important, and that goes back with the, the employment agreements that Paige was talking about. There might be some assets in there that exist, but they don't actually physically exist yet, because it's when you leave the company or when you are retiring, you get paid out a certain amount of money. Your spouse is entitled to a portion of that, the marital portion of that. So you just need to make sure that that's included in your agreement.
Okay.
When you're divorced.
So I want to hone in as a start on some small business complications that can really lead to issues. And so I'll give a little scenario. Had a personal friend who ran a large cash business. There was a lot of questions from the spouse when they were divorcing about whether he had been reporting true income. And maybe you can talk about that a little bit, because I think it kind of weaves into the expenses of the business and the valuation of the business. And can you maybe talk about that a little bit, Lauren?
Sure. In terms of, I think that's a common thing that happens, and it's a common allegation that's levied by a spouse who's not involved in the business or doesn't know the finances as well as they wish they did when, once they start the divorce process. So obviously we're going to look at expenses, annual expenses, because you can impute income to a party based on expenses. I mean, if your annual expenses exceed, the income that you're, alleging that's your full income, then, there's an inconsistency there, and the court can impute income to you. Also, you'd have to, this is when you probably want to bring in an expert or a forensic, which a forensic would be a CPA, to maybe take a look at the business. A lot of times, without speaking to their spouses, a party will invest bonuses back into the business if they're an owner, depending on the percentage of their ownership. So, you need to know if over the last 10 years, your spouse has been putting back, large bonuses, $500,000 bonuses back into the business to grow the business, because that's going to impact, your marital portion of that business, because that was income that you were entitled to. So, this is when the discovery process would start, and you would be, your attorney would be making demands to opposing counsel, for the employment agreement, for any documents evidencing like assets that stock options, any of those types of things. And I do think there's value in kind of just really getting that CPA to come in and do an appraisal early on, instead of dragging it on and litigating back and forth with the other side. So because you don't have an idea of what the marital portion is of the business until you know what the business is worth. Sometimes you can just figure it out off the tax return, and sometimes it's a lot more complicated than that. Especially, the bigger the business is, and hedge funds, for example, you can't just necessarily look at the tax returns without and know, the value of the hedge fund, and then your partner's, ownership of it is all important. So
actually that raises a good question. And either one of you can, I was actually in that instance too. That was a solo owner. What happens if there's partners, whether they're other family members or just a business partner? I mean, how can this also affect a business partner? How is it handled? Paige, do you want to maybe take that one?
Yeah. So the non-titled spouse is a non-titled spouse, right? So they don't have a legal ownership interest in the business vis-a-vis their relationship to the business, and the partners, they do not have, they are not an owner. But in the context of their marriage, for that divorce to happen, that is a marital asset vis-a-vis the non-titled spouse and the owning spouse. So whether or not their interest in the business is paid out with cash, or whether it's paid out with actual ownership of the business, that's when titled ownership could transfer. That is not usually an ideal outcome for obvious reasons. You are looking to separate yourself from this person. Now you're going to, it wouldn't make sense to them become a business.
Like, why keep dragging on the pain?
Yeah. But one of the things that we were talking about was the famous Bezos divorce. Right. And yeah. I was just doing a little reading, and so his ex-wife has retained a 25% ownership interest in his shares in Amazon, but she has relinquished all voting rights, right? So that is one way to preserve, an interesting way to preserve your interest in the marital asset. And you can think about how that benefits both parties, right? Because right now, Amazon probably has its highest valuation ever. And higher than probably the valuation would have been at the time of the settlement of the divorce, but quite high, okay? So the wife, the ex-wife, and you have to forgive me because I can't remember her name right now, which is terrible, but
Mackenzie.
Okay, so she has an interest in keeping an ownership right in Amazon, because that stock could climb.
Yeah.
It very much could also decline. Yeah. So she takes on the risk. He does not have to buy her out if the stock would decline, and she also gets to take advantage of the gains if it appreciates in value. So you do kind of play the market, but you also then have the opportunity to relinquish control and not actually be a decision maker in terms of how the business gets managed.
That's such a good point, because I think sometimes, especially, in a divorce, things can get so heated and people can start digging in their heels, right? And then you can almost cut off your nose to spite your face, sort of thing. And you at a Bezos level, there's a lot of other lawyers involved, and there's probably all sorts of contracts involved, but maybe not so much for that new tech entrepreneur or even the dry clean owner, So, okay. I think for the time being, we've kind of covered the small business side. Let's turn to the executive comp side. I know on that area, like I've already admitted, there's a lot that I could learn there. So let's talk about the possible. We talked about that it's like pensions, employment contracts. I'm going to kind of just let you both start in, and Lauren, you start. What are the things that people want to consider? now in the future, we kind of touched, as we prepped for this, on the idea of, you know, a person like a Matt Lauer, you know, who had a huge employment contract, and then there was the Me Too movement, and he was let go by NBC, and then his wife divorced him. And how did that severance package work in? So that's the sort of very high level, you know, comp packages that we're talking about. And it doesn't have to be in media, it could be in anything. So I'm going to throw it over to you guys to kind of hash those things out, because I think they're important.
Well, I think one of the biggest thing is you have to make sure that, you know, you get the employment contract, and then you have to review it, and you have to kind of determine, you know, what parts of the contract have already, at the time that you're contemplating divorce, what parts of the contract have like the earned income versus future earnings, because you have to distinguish between those two things, because you're only going to be entitled to what has been earned up to, you know, the at the time that you're getting divorced. You're not going to be entitled to what will be earned after that. But that doesn't mean that it's very complicated, and it's very specific, and, you know, that's why you have to have experts, you know, go over the contract. And, you know, if it was complicated, you might want to bring in a financial, you know, advisor, an expert to take a look at the contract, and, you know, to assist in making a, you know, determination as to what's to do with the, you know, the assets. And
I'm going to interrupt you for a second, because we actually got a great question while you were talking, which maybe you've got people that you've done this with. The person asked in relation to the employment contracts, it says, do you recommend your potential clients also consult with an employment attorney in circumstances where the partner is a non-titled owner but performed work for the company, to ensure that there are no potential labor law violations, such as pay issues by the business? So I think actually an employment attorney could help both on the small business side maybe and on the executive comp side. Have you had any experience in this area, either of you, and what would you recommend?
yeah, I mean, I've had instances where we wanted to you know, where we've had clients that have had employment employment concerns, and we've discussed it with employment lawyers to specify, to make sure that they're being compensated what they're supposed to be compensating, because that's all a marital, you know, it's all marital asset. So when you're talking about earned income, if you get divorced and then say your partner commences a lawsuit for past earnings that you know, for some reason they weren't compensated for, if there's a contract dispute between the employer and the party, I mean, if that's what that individual was asking about, you know, you would want to bring in an employment lawyer to advise on that in advance, particularly if this say lawsuit would be commenced after the divorce. You want to prepare for that, or include that in your stipulation of settlement, in your agreement for your divorce agreement. That's all, like, you know, very important. I mean, in terms of Matt Lauer, it was a little bit easier because that all happened before she filed for divorce. So she's entitled to, you know, she's, you know, absolutely.
But the important thing to know is that severance package was paid out, I believe, over time. And so it was not a lump sum. And so that would have been wrapped into it. And I think that, you know, at a high level, there's a lot of people, you know, once you get to a certain level within any sort of company where those sorts of packages are, you know, the severance packages are rather large. Oh, go ahead, Paige.
Because I just thought of something. If to the question that was posed by the audience member, if there's a concern, and I wonder if the question is asked around the concern about the business taking on risk for not appropriately compensating employees, right? So there is an issue, especially in New York State and New York City. New York City is pretty serious about classifying employees properly as either W-2 salaried employees or 1099 contractors. And a lot of small businesses, you know, will try and keep employees as contractors for as long as possible, because you tend to avoid payroll tax, health insurance obligations, and a bunch of expenses. So and there are serious penalties for misclassifying an employee. So if there is an audit on the business and there are employees that are misclassified, that can actually impact the value of the business and the cash flows of the business.
Well, and I think I was going
Yeah.
to say, as I'm re-looking at the question too, I think what's interesting is, as I'm looking at it in more detail, it's the partner. So say you're the spouse who is the titled owner and you're the non-titled spouse, but you're working for the business.
Right.
But not classified as an employee. Like, I think that's, there's.
I wonder if that's part of what's being asked. And if it is, then yeah, you would definitely, to Lauren's point, you would definitely want an employment lawyer to review that for you to make sure that, you're not going to be also jointly liable. I mean, possibilities. So, and then.
Oh, go ahead.
Yeah, I just wanted to correlate the Matt Lauer example to, equity compensation that vests over time. So there's like graduated vesting and there's cliff vesting, but if you've got equity compensation that was granted during the marriage and then it vests over time, let's say there's a 3-year vesting schedule, right? And you have, so you earn 33, I should have chosen 4 years. 4 years and you earn 25%. The stock vests 25% every 4 years. And then you get divorced in year 3. It's important to know that, up until that point in year 3, the equity or the stock options that have vested, that is considered, the marital asset.
Right.
But then there will be a portion that's excluded.
Right. Okay. Anything else on stock options or pensions we want to make sure that, I think it kind of weaves into what you just said, but I just want to make sure there's nothing incentive based on comp that people would potentially be missing. And again, I encourage the participants, if you have a question about executive comp specifically that maybe you've had an experience with, please shoot them our way for Lauren and Paige to answer. So Paige or Lauren, are there any other areas that we want to make sure we cover before I move on to some other questions?
Lauren, if you have anything, I'll let you go first, but I was just looking at my notes and I think I have just one little detail to recap on.
Yeah, no, I would just touch on pensions. Pensions are a little bit easier than some of the executive compensation because it's an asset that exists. It can be valued by a company. You don't necessarily need to have a CPA come in. The company values the pension, and then they can also make the determination as to what the marital asset is and what, based on the length of the marriage, what the non-titled spouse's share is of it. But you do want to make sure that you protect, we talked about it, the sick days and the, any other types of, entitlements you could have towards it. There is at the end of, when someone actually retires and they elect what they're going to do moving forward, there's different types of way they can take the pension. They can take it where they are solely paid and you get your share of it, or they can take it where you're a survivor. The right to survive, I couldn't think of it for a moment. The right to survivorship is another consideration that you want to take when you're determining and figuring out the agreement for your share of it. Right to survivorship, if your ex-spouse passes away, relatively young, shortly after retirement, could make all the difference for you. So you have to kind of make a determination on that. And sometimes parties will get life insurance instead and, waive the right to survivorship. So there's pensions are easier because it's an asset that exists, but there's still considerations that you need to think about before you make a decision on to how to settle that the division of that asset. So
okay. Paige, go ahead, and then I have a question from one of the attendees. You hit on your point, and then we'll take one of the questions that came in.
So I just wanted to also say, in terms of like finding these things out, the first place we often look, and the first place we ask clients to start working on for us is the statement of net worth that each party will have to disclose. And sometimes, assets such as, equity compensation, deferred comp are left off, and it can be inadvertent. So you do have to sort of look behind those things. And it can be touchy because you try to avoid the getting to the point of having to send subpoenas to your to your spouses and your adversary's employer. But it can reach that level. You want to be looking at not just the employment offer and agreement, but also, employee manuals that outline, benefits packages. And sometimes you can even find it in, for publicly traded companies, you can find these things online in their public disclosures, their SEC filings.
Well, and I would imagine if your inclination is to try to hide some of these things, maybe you haven't inadvertently forgotten it.
That's right.
If your inclination is to hide it, it will likely cost you more in the end. Would that be correct if you're trying to hide it? I mean, because then you end up having to hire, maybe you end up having to litigate or motions, right? Can you kind of talk about that if you're somebody who might be a little inclined to dig your heels in rather than just being forthcoming?
Yeah, I mean, you're right. It is just going to make the process longer, more expensive, and more painful. And so I'm just going to take this opportunity to say, if you are inclined to want to hide, then but remain married, I would suggest you think about a postnup as a way to clearly define what your expectations are in the event, you have to talk about divorce. Yeah. And that can be a tough nut to crack as your professional success is skyrocketing, and now you're telling, your spouse that, you may not be willing to share all of it. And that's really the root of the conversation, but I can guarantee that will open up pathways to a healthier relationship.
Yeah. Yeah. Actually, why don't you touch a little bit on, you said postnup, but how could a prenup even avoid some of all of this on either side, whether you're a small business owner or you're a high net worth executive, knowing that you are on a trajectory to only go further?
The cleanest way is to say, we're just going to keep these assets separate and all or certain parts of our income separate. And then beyond that, you can, if in the context of a small business owner, you can at least stipulate to a valuation method if you need to go there. You can stipulate to what I call anti-liquidation clauses, which means, hey, fair enough, I acknowledge that there is an asset here that you have, that a portion of should go to you. But if we don't have enough liquid assets for you to get bought out, then let's agree that we won't throw the baby out with the bathwater, if you will. And let's agree that no matter what, I can pay you out over time so I don't have to sell the business interest. Yeah. Right. So things like that. And, and then you can also talk about what that installment payout should look like.
Okay. All right. So I'm being, go ahead. I'm sorry.
If there's a family-owned business, a prenup is something that you should really be considering. I mean, we've seen it where it kind of just rips families apart, especially if it's a family-owned business that's been around for generations, which is not that uncommon. When you have a prenup, you can, preserve the business and protect the business. If the company is doing so well and, the earned income is just, skyrocketing, the non-titled spouse is going to benefit from that by way of, spousal maintenance, by way of child support, so it is really important when you have partners, because it seems like there were a couple, like the question, when you have partners who are titled and not a part of the marriage, like business partners, I could see there being a concern when people are getting married, if this non-titled spouse is going to demand that they be bought out, and there's not, like Paige said, the liquid assets to buy them out. That's when business partners get affected, and it can be problematic, and it can cause stress on the marriage when you're having hard times. If the titled spouse is feeling stress at work from his business partners or her business partners because there isn't this protection for their business.
Well, and I would imagine too, it's not just the business partners. I mean, you have employees. You've got to protect your employees as well. I mean, this isn't just about, if you own a business, you likely have employees, and those employees are relying on you for their income. So, it's well-advised financial advice. We have just a few questions on our end or my end that I want to make sure we address. And then we do have some questions from our attendees. So let's try to do lightning round because I am cognizant of everybody's time here. You know, Lauren, especially as the lead litigator for our TZ Zandri, I just want to make sure, like, what is that discovery process like if you end up having to go to litigation, and who are some of the professionals that might need to be looped in?
So it starts out with the demands for the documentation, then there's the review of all the documents that are disclosed to you. When you do have parties that are difficult and don't want to turn over information, there might have to be motions before the court to compel. You're going to be required to turn over all your financials. The court's going to make you do it. If you don't, there's no reason for it not to be turned over.
You can run, but you can't hide.
And they can sanction you. You know, the courts can sanction by, you know, fining you, or, you know, they can sanction your, you know, attorneys. They don't, I mean, attorneys very rarely get sanctioned, because it's usually not them who don't want to turn over their financials, it's their clients. So, I mean, and when I say, like, you know, they're going to make you pay counsel fees and things like that. So it's really just not advisable to not turn over the documents. There's depositions where you'd be questioned, you know, about, you know, you'd be questioned. They can bring in your say bookkeeper. They can bring in, you know, witnesses who have information about your business. The expert, the most important and key expert in valuations is a CPA, and there are not all CPAs do forensics, but you know, all the forensics that you hire to go to court are going to be have that CPA background. And what they do is they come in and they go through all the documents for the business. So the tax returns, you know, the books and records, all of that, they're going to go through it, and they're going to, a lot of times they're requesting additional documents and all bank accounts for the business, bank accounts for, you know, they're going to look at everything. And then they're going to produce a report, and the report gives the value of the business. And, you know, the titled partners share in that business. They'll give, you know, they'll be able to, you know, they're going to look at the formation documents for the business, which is going to indicate how much of, and then if it really gets pushed, you know, and you're litigating it all the way through, that forensic is going to have to testify. Now, real quick, and I'll do it really quick. You have the courts a lot of times will try to get the parties to have a neutral forensic. So that will be a neutral forensic that comes in and does the valuation, and both parties contribute and pay for that. If you disagree with the valuation, you can bring in your own forensic, and then you're going to carry the cost for that. And the other side, the other party can bring in their own forensic as well, and they're going to carry the cost for that. So that all can add up to a lot of money.
Just quickly, how much do you think on average, just to get started, to have a court-appointed forensic and then each party gets their own?
Well, you're talking between like $30,000 and $50,000 at least for each forensic.
And you could save all of that money and time if you're just upfront. And I also want to, and Paige, I've told you about this, that I had a friend whose spouse was threatening to call the IRS because he didn't think and you know, what she was failing to realize was that she was a part of signing those tax returns, and that was a silly threat. So, you know, this also raises to me, Paige, the idea of like, these all seem like they could always be a little contested, a little heated. Is it even possible in any of these scenarios to go through mediation, or is it because it's so layered, you can do mediation in these?
Oh, yeah. But, you know, a key component of mediation is the willingness to be transparent.
Yeah.
And if both parties are not coming to the table, at least, you know, with the initial willingness and readiness and ability to be transparent, if they can't be brought to the water to see that that is what will serve them best, either in court or in mediation, then you'll probably have to go through the judicial process and have the court intervene to, as Lauren mentioned, compel the disclosure of what's being hidden.
Okay. Let's turn to, I've got 4 questions. So let's dig in on those questions. I hope you guys are ready. The one question, Lauren, you might have to think back to something you had said, because it's the person said, you had said to look at annual expenses to impute income in a small business. Did you actually mean annual living expenses or annual business expenses?
Both.
Both.
I mean, both would come into play, you know, because you want to, especially if you want to do a like complete job, you and get the most accurate result. You're going to look at what the business expenses are, what the revenue is, and then, you know, because a lot of times small business owners will pay some personal expenses through the business, and you know, so you'll have, I don't think you could accomplish that without looking at both expenses.
And honestly, yeah. I don't think it's just small business owners that pay stuff through their business. I mean, there's some, I'm sure some tech companies and some hedge fund companies where it's like, I think anytime, isn't that something what somebody's trying to do? Okay.
Well, that's tax avoidance. It's
yes.
not tax
tax avoidance. The next question is, a union worker's primary and largest family asset by far is his pension. He wants a settlement that does not touch his pension. Any ideas on how else to accomplish this? I think it's a good question.
Yeah, I mean, it's definitely a possibility. It depends on a lot of different factors. It depends on how long the marriage was. It depends on if the other party has their own assets, their own pension, you know, their own retirement assets, whether it be 401ks or, you know, IRAs, things like that, or, you know, it depends on all those things. Or it depends on if the family, you know, if the parties own other assets together, you know, if you have a house, you could, you know, bargain your pension against, you know, the house and say, well, I'll give you the house, or I'll give you more of the house. And it depends on the values of everything, right? Like if the pension is all that they have as a marital asset, it's going to be tough to get anyone to agree to waive their interest in that. And I mean, you could get them to agree to pay out if there's cash. So yeah. it would be negotiating other assets against that asset and to try and preserve it, which happens. We have that happen in a lot of cases where there's other assets that, you know, or if it's a short-term marriage.
Yeah.
And I want to add that, Julie, I just want to add one detail that a lot of clients don't realize when they first come to us is that for the most part, although there is a new provision in the domestic relations law that I'm going to mention, for the most part, fault does not get taken into consideration in the distribution of assets. Yeah. Okay. And so if the pension is the only asset, as Lauren said, you're not going to be able to use I'm generalizing adultery as a reason why the pension should be distributed, you know, other than the equity, you know. So, but in the factors for determining equitable distribution, right? Because we were talking earlier about how it's not equal. New York has just basically amended the statute to now take domestic violence into consideration.
Yeah.
So, you know, if that's in play, and we don't know how the courts are going to weave that into determinations of equitable distribution, but we are definitely keeping our eyes peeled and our ears to the ground to see if in an example such as what, you know, the audience member was giving, if that, you know, if we're trying to avoid dividing the pension and that's the only asset, there's a potential that if domestic violence is in play, that could be used as an argument in favor of the non-titled victim spouse.
Good. That's a very important new point to raise. So, all right, next question. For pension valuation, would a court look to U.S. Treasury interest rates now, which are abnormally low, 10-year Treasury less than 1% versus historical anywhere from 3 to 10%, or use AAA corporate bond rates, which are more in line with historical rates? Lower interest rates mean the pension is valued higher. That's another great question. I don't know if it's something that go ahead, Paige, you look like you have an answer.
it's the valuations are done by, you know, like the court's not going to value the business, or the, I'm sorry, the pension. The pension's going to be valued by a company. We definitely, I'm imagining it's historically, like, I don't think that they're going to use, they use averages. Like, I do know in terms of when they're determining like the age, they use the death rates, like the average for women and the average for men. So I'm imagining that they use average. We can definitely, I don't know, Paige,
I honestly, that was my answer. I'm not entirely sure if it's the same for every pension, in terms of what they use as a standard for determining the value, and the appropriate interest rate to make that calculation. But the answer is that there are experts for that.
Yeah.
That it's cheaper to hire those experts, a company that does nothing but pension valuations, and they send the report, and that's what the judge will rely on.
Yeah.
Does the judge, and I think you said this earlier, but I want to make sure that I processed it. Does the judge appoint who's valuing that, or is that something that you guys recommend as to who they should look at for those sorts of valuations?
The judge can appoint, normally, and I would say like 95% of the cases, in terms of pensions, the parties just agree to have somebody, you know, they agree to a company to value the pension. Yeah.
Last question we have is: a property settlement note in a divorce, payments due to lower income and asset spouse, able to be wiped out in a bankruptcy filing by the payer? I'm not sure, but is a property settlement note in a divorce? Right. Does that make sense? I'm sorry, it's not making.
Yeah, we typically try to conclude.
Go ahead.
You're breaking up a little, Julie.
Oh, sorry to our viewers.
Yeah, I think the question is whether or not the ex-spouse becomes a creditor in a bankruptcy filing, and whether or not the payout that is owed to them will get dissolved in a Chapter 7 proceeding.
I think it depends on what the asset, like what the payments are for, whether if it's for an asset that you own, or if it's, you know, child support or maintenance or spousal maintenance. All of that comes into play. You know, child support can obviously never be, if you were talking specifically about equitable distribution of assets, you know, we would bring in a bankruptcy attorney to kind of discuss and go over that. But child support and spousal maintenance, I don't believe can ever be discharged in a bankruptcy proceeding. Yeah.
Okay. Yeah. Can you, I'm sorry, did my connection get better? No.
You're back.
Okay, good.
It's okay.
Okay, good.
Was that the last question?
Yes, it does. Yes, that was the last question. That seems to have answered it. So I'm so excited, all the questions we got. That was great. Is there anything else that you ladies want to make sure that we cover before we wrap this one up?
I think we're all set. Yes.
Okay.
Yeah, this is about the timing, and I'm so happy.
Okay, I clearly am losing my video. Thank you. Our next coffee talk is August 27th. Thank you.